when we look at the sort of non-family law cases, it's really important to understand how binding an arbitration award is on your case if you decide to advise a client to enter into one, to an arbitration contract, and really how difficult they are to avoid, even if the arbitrator makes a mistake.
You're listening to the Texas Family Law Insiders Podcast, your source for the latest news and trends in family law in the state of Texas. Now here's your host, Attorney Holly Draper.
Today we're excited to welcome Audrey Blair to the Texas Family Law Insiders Podcast. Audrey is board certified in family law and has been practicing since 2002. Until 2014, Audrey was a family law litigator in the Austin area. She then pivoted her practice to family law appeals and a legal research and writing practice. Audrey received her undergraduate degree from College of the Holy Cross in Worcester, Massachusetts, and she obtained her JD from Baylor University School of Law. Family lawyers hired her to write trial briefs and summary judgments. When not practicing law, she loves spending time with her husband, Bill, her black lab, Roscoe, and digging in her garden. So thank you so much for joining us today.
Thank you. I'm really glad to be here, Holly.
So why don't you tell us a little bit about your background?
Well, I've been licensed since 2001, and the first couple of years of my practice, I worked at a nonprofit in the Austin area doing all family violence work, so protective orders, things along that line. And then I shifted into a private practice for the next 13 years, worked in Austin primarily. And then I decided that I was sort of burned out on family law litigation, and I took an epic road trip for a while, kind of do a little reset, and then I shifted my practice into what I do now, which is legal research and writing for family lawyers. I write summary judgments, I do trial briefs, and then I've also picked up some appeals and mandamus work here and there.
So when you're doing summary judgment and brief writing and things for attorneys, are you basically ghostwriting it for them, or are you appearing in the case?
Yes. Sort of what I envisioned was, maybe I would be good support for somebody, for example, who's a solo board certified lawyer that may need an extra set of hands, in their cases. And I work at kind of a reduced rate to save their clients money. And I'm always pretty much ghostwriting in the background, with the exception of a few appeals here and there.
So today we're here to talk about a topic that many family lawyers, in my opinion, are not familiar with, and that is the topic of arbitration. Can you generally describe what arbitration is?
Sure. Arbitration, at its most basic form, is a method of resolving a legal dispute out of the courtroom. Generally, arbitration arises because two parties will contractually agree to arbitrate a matter. And once they do that, they will submit their issues to a neutral third-party arbitrator who is not a sitting judge, who is just usually a lawyer, that will resolve their issues for them. And it's very easy to enter into arbitration, an arbitration agreement. All you have to do is simply agree in writing to do so, and then you have for the most part, a binding arbitration agreement. The goal of arbitration is to ultimately end up with an arbitration award from the arbitrator. And from that point, the trial court should sign the arbitration award into a court order unless there's some narrow exception to avoid the arbitrator's award. And as we'll kind of talk about probably later today, Texas law heavily favors enforcing arbitration agreements. So our jurisprudence is certainly supportive of parties entering these kinds of agreements.
So do you have the same sort of defenses to an agreement to arbitrate as you may have to entering into a mediation settlement agreement or other types of contracts where you can try and weasel your way out of your agreement?
Yeah, that's a good question. So I would say that the defenses to an actual contract to arbitrate are very limited to things such as, unconscionability, fraud, duress, etc. They're very, very narrow in the sense of defenses to a formation to a contract. So in that sense, I guess they would mirror some of the defenses that we see to trying to get out of a mediated settlement agreement.
So I know in Texas, we have the Texas Arbitration Act. Can you talk a little bit about what that act is and what it entails?
Sure. So the Texas Arbitration Act is codified in Chapter 171 of the Civil Practice and Remedies Code. And I kind of double checked this morning. There are about 40 subsections in that act. There's a lot in there. So if you're dealing with an arbitration agreement or an issue with arbitration, it's really important to go look in there and see what your options may be and kind of what you're dealing with. So the Arbitration Act covers everything from provisions compelling or staying arbitration, the appointment of arbitrators, arbitration procedures such as your entitlement to a hearing, and the rights of the parties during an arbitration proceeding. It also contains provisions about how and when a trial court or an arbitrator may set aside an award or when the court must confirm an award. So it covers innumerable things, that you may want to look at if you're dealing with an arbitration issue.
How does it apply in family law cases?
Well, first of all, there is a case that says we do apply the Texas Arbitration Act. And so that's a good place to start. And there are also some special provisions in the family code dealing with arbitration, and they're included near the subsections that deal with other ADRs, such as mediation. So Section 6.601 of the family code says that the court may refer a case to arbitration if the parties agree to do so in writing, and that thereafter the court shall render an order reflecting the arbitrator's award, and that's for divorce cases. And Section 153.0071, which is, of course, in the chapter dealing with SAPSers, provides also that the court should refer the parties to arbitration in a SAPSer where they have agreed to arbitration. With SAPSers, however, there's a really interesting provision that parties should be aware of, which is subsection B of 153.0071 that says that the court shall render an order reflecting the arbitrator's award unless the court determines at a non-jury hearing that the award is not in the best interest of the children, or the child. So that is a big out, in my opinion. If you're looking to avoid an arbitrator's award, you could attempt to prove that it's not in the child's best interest.
So that would definitely make it less binding than an MSA, where the court does not have that authority.
Definitely. And the family code puts the burden on the person seeking to avoid the award, but certainly, if you end up with an award that your client thinks is not in the best interest of the child, you can certainly try to avoid that award.
So I can tell both in 6.601 and 153.071, it says that the parties must state if the agreement is if the agreement to arbitrate is binding or non-binding. Why would anyone want to agree to arbitrate if it was not binding?
I have never figured that out myself. The only thing I could think of is, maybe you've got a case where both parties, maybe it's a unique issue of law, a unique set of facts. Perhaps you just want to see what a third party might do before you enter a settlement agreement or go to a trial. That's the only, sort of strategic reason I can think of to do a non-binding arbitration.
Because I'm thinking somebody's not going to be happy with that award. So if it's not binding, why are they going to stick with it?
Right.
So are there any ways that a judge can order parties to arbitrate if the parties aren't agreeing?
So there are, and I haven't prepared for this on the appropriate code section, but I believe there's in the chapter 154 of the Civil Practice and Remedies Code, I think there's some sections in there that deal with referring parties to non-binding arbitration, but I don't know that for sure.
Have you ever seen it in family law context?
I've been licensed for 20 years and I've never seen it ordered. So it seems rare, for my.
If it happens at all, yeah. So because I don't think there's a ton of arbitration going on in family law, maybe there is, and I'm just blissfully ignorant to that fact, but are there cases outside of the family law context that are helpful in considering this for family law cases? Yeah,
so I think when we look at the sort of non-family law cases, it's really important to understand how binding an arbitration award is on your case if you decide to advise a client to enter into one, to an arbitration contract. and really how difficult they are to avoid, even if the arbitrator makes a mistake. And I'm going to kind of go through a couple of cases that kind of drive these points home. There's a Hoskins case. It's a 2016 Texas Supreme Court case that says, unless the Texas Arbitration Act mandates otherwise, unless there is a statutory ground to set aside the arbitration award, the court must confirm the award. So, and we'll go through probably the exceptions here in a few minutes, but there's very little discretion for a trial court to get around an arbitration award. And as I mentioned earlier, there's another Texas Supreme Court case, Forest Oil versus El Ruccio Land and Cattle Company, that stands for the proposition that even if the arbitrator decided an issue incorrectly, like a legal substantive issue, that is not a basis to set aside an arbitration award. So even if they got the law flat out wrong, as long as you're within the scope of the arbitration agreement that the parties had, that there's very little you can do to correct an error made by the arbitrator. And then lastly, and I think this kind of gets to kind of thinking about error preservation. This is the Centex versus Friendship West Baptist Church. It's a Dallas Court of Appeals case from 2010 that the party wanting to vacate an award has the burden to bring forth a complete record establishing the grounds for vacating the award. So I think in my experience, a lot of arbitrations in family law cases are, letters to the mediator or some off the record conference or meeting where the arbitrator makes a decision and then issues a written award. You have no record showing what happened. So, even if you wanted to go to the trial court or an appellate court, you'd have no way of showing that there was error. So I think, we need to kind of look at arbitrations more in the context of litigation. If you anticipate that your client's going to want to try to set it aside, you need to be thinking ahead of time. So
from a logistical perspective, then, if you are heading into arbitration, should you treat it the same as you would a trial?
I would consider having a court reporter, or I would consider some, detailed written arbitration procedures that establish a record. So let's say we agree we're going to submit everything in writing to the arbitrator, and the arbitrator is going to rule within 10 days. And then, just to kind of create things that you can file into the court's record in the event that you decide, your client decides to challenge the award.
So does arbitration often occur kind of on a submission basis, or are people having hearings? Everybody sits down at the table together. How do you usually see it happening?
I've seen it both ways. I think if, for example, the parties in a divorce agree that the arbitrator will resolve drafting disputes, I've seen that happen by submission very regularly. I've also seen, and I've actually been involved as a lawyer for one of the parties in a contested arbitration where we went to the lawyer's office who was serving as the arbitrator, and we put on witnesses and the rules of evidence applied. So, I think it can come in many, many shapes and forms.
If you're going to go that route where it's contested and have witnesses, all that before an arbitrator, what benefit is there to doing arbitration as opposed to just taking it to the trial court?
I think that's a really good question and a really good consideration if you're a lawyer who's considering or who's advising a client about arbitration. Certainly, I think arbitration and private judge, for example, kind of have an element of privacy where you aren't litigating your disputes in a public forum. I think that's a really big feature and attraction to a lot of people. With an arbitrator, you may have more control over who the arbitrator is as opposed to your judge, where you sort of you're left with whatever court you're filed in or whatever county you're in, whatever judge you're assigned to. So I think that's appealing to a lot of people. Certainly, if it's a full-blown arbitration like a trial, you're still going to have the same costs, right? You're going to have your experts and your court reporter and your, the time that you take. So for your lawyer attorney's fees. So I don't know that you necessarily save money from that perspective, unless it's a, in writing kind of arbitration.
So you mentioned a private judge. For anyone who is listening that's never heard of that before, it's parties can agree to hire a former judge or something of that nature to hear a case privately outside of the court where it is set. we've certainly looked at that if we really didn't like our judge or if we weren't going to be able to get into court for a really long time. What would make you choose private judge versus arbitration or vice versa?
I guess it would depend on whether there was an arbitration agreement already that you had to live with. For example, if you had let's say your client signed a prenup years ago and it's got an arbitration provision in it, then I think you're stuck with arbitration. But I don't know that there's a huge difference. I guess the most important thing would be, is this binding or not, right? And how much judicial experience does the private judge have? Like, what do you know about them? If they've judged before, they may have a bit of a track record that you can more properly investigate before agreeing to that person.
So how does a family law case differ in arbitration from a case in traditional litigation?
We've kind of, touched on this a little bit, but the things that I have seen the most are sort of come down to the scope of the arbitration agreement. So most cases I have seen usually just have a small piece of the case itself that is submitted to arbitration, as opposed to a full-blown trial on all issues. For example, there are many reported cases out there that, once you agree to, for example, a provision in an MSA that requires all drafting disputes to go to the arbitrator, that the court is going to enforce that. So there are actually two Supreme Court cases, the Milner case from 2012 and the Loyat case from 2017, that sort of affirm that, yes, once we, enter into this agreement, then the court's going to enforce it and the arbitrator is going to decide it according to whatever is in the scope of the contract. And I think another, big difference in family law cases is sort of where we find agreements to arbitrate. They can be in mediated settlement agreements. They can be in, as I mentioned before, like a premarital or postmarital contract. They can be, let's say that perhaps one of the parties owns an LLC and the spouse has signed on to the member agreement that has an arbitration provision in it. That's another way that, these things are sort of, I think a practitioner kind of needs to be on the lookout for these things. The parties have kind of independently signed any form of contract before they come into your office. So
if you find yourself in a situation where the parties have agreed to arbitrate for one reason or another, or they signed something forever ago and now someone's going to hold them to it, how do you go about picking an arbitrator?
That's a good question. A lot of times the contracts I have seen will have either that they will have an arbitrator named in it. Oftentimes it's a mediator who has been assigned to arbitrate any drafting dispute. So that's obviously, a pretty simple resolution. Other arbitration agreements will have a provision that the arbitrator has, certain qualifications or must be, a member of certain organizations in order to arbitrate the disputes. But kind of where I always start is talking to colleagues, say, hey, I've got this case involving characterization of a company, or I've got, I'm challenging a prenup agreement or something. And I really like to talk to other lawyers who have, who may know an arbitrator that would be at least attuned to the issues that we're going to go into arbitration.
So arbitration agreements, as we mentioned before, we often see them in MSAs. A lot of mediators include those as standard language, that if you have any disputes, you're going to arbitrate with the mediator. Do you think that's a good idea?
I always advise clients to take those out because when you go to mediation, sort of sacrosanct, the mediator often sort of will say, I'm a neutral person. I don't know either. I'm not here to favor one side or the other. I'm here to have you reach an agreement. And when we put, and a lot of clients get pushed at the end of mediation, right, to sign the agreement and leave a lot on the table. And many of them do not feel good about it. And I think when you put the mediator in the role of arbitrator, even if at some point in the future, I think that can have a really negative impact on the client's sort of investment in their settlement agreement. And also, I think there's kind of this like false idea that a mediator is going to remember your case or the facts of your case. I've mediated probably 60 cases, and I can't remember any of them. I mean, this kind of idea that the mediator liked me or is going to rule favorably to me. I think that I'm a little weary of trusting that theory. So on the other hand, I think that sometimes, especially when you get to 8 o'clock at night, you've been mediating all day and you're stuck on one issue. I think it's a good idea in some instances to say, you know what, let's arbitrate this. We'll do it by submission, just as long as everyone's clear on what the parameters are. I think it can be a good way to avoid the courtroom for people.
And so in that scenario, that's something you're agreeing where your MSA is not resolving all the issues.
Right.
So you're, whatever this outstanding property or whatever the issue is, agreeing to meet to arbitrate that. I think if you have a client that is very concerned about public litigation of their private matters, they've got some, who knows, maybe they're a politician or somebody famous or whatever else. I think that can really provide a benefit to clients who have those issues. So you go to arbitration, the arbitrator makes a decision and you don't like it. Are there any, or he got wrong? You talked earlier about even if they get the law wrong, are there any options for appealing an arbitration decision?
There are. So I'll kind of address 3 different things. So you can go to the arbitrator and try to get the arbitrator to correct or change the award. You can go to the trial court, you can go to an appellate court. Of course, Texas Supreme Court sort of incorporated in there if you're inclined to go there. So first, you can go to the arbitrator and ask the arbitrator to clarify, modify, or correct an award. And you have to do that within 20 days of receiving the award. So there's kind of a short timeline in there. And then you can also go to the trial court, and you have to do that within 90 days of receiving the arbitrator's award. So I think the practitioner needs to be very aware of these short, especially going back to the arbitrator, of these really, really short deadlines. So we kind of talk in terms of correcting, modifying, or vacating an award. Those are kind of 3 different things. The grounds to correct or modify an award are very narrow. They are an evident miscalculation as one basis, and that is literally like a mathematical error or a improper description of property, something sort of like a nunc-pro-tunc, if you will, sort of just basic math error. You can correct or modify an award where the arbitrator issues an award on an issue that was not submitted to him or her. And then lastly, you can correct or modify an award if there's an error in form, but that doesn't actually affect the award itself. So I consider these extremely narrow bases to correct or modify an award that no one should count on being able to utilize in most arbitration awards.
So is there a requirement that you ask the arbitrator to clarify, modify, or correct an award before you can ask the trial court to do it?
I do not believe you have to do that. I do not believe you have to. So there are also some grounds to vacate the award. So, and these are, again, very narrow: corruption, fraud, undue means, kind of the, same things we might see to set aside a mediated settlement agreement or contract. You can attempt to vacate it based on the evident partiality of the arbitrator. And this ground is kind of interesting, and I think especially in the family law context, because if you're asking, for example, another family lawyer to arbitrate your case, we see each other at Advanced Family Law. We are social with each other from time to time. And, does that create a partiality question? I think that erring on the side of full disclosure of your relationships with the parties is really, really important if you're going to step into these arbitration rules. So, and again, you can seek to vacate it if the arbitrator exceeded his or her powers. I will say there's a lot of case law out there that calls on the trial court to broadly construe arbitration agreements. So I think the arbitrator would have to go way off into left field to exceed his or her powers under the agreement. And then lastly, you can attempt to vacate the award if there's any procedural misconduct, such as, failure to allow the parties to have a record, if that's what the parties have agreed to do in their procedures. So, but again, and this, I want to kind of emphasize this point, you've got to make a record of all this stuff. If there's, procedural misconduct, how are you going to prove that to the trial court and then ultimately be upheld? So, and so these methods of trying to vacate or correct an award, got to take it to the trial court first, right? Before you can go to the appellate court. And so, again, thinking about preserving error is really important when you're dealing with these things.
So it's scary to think that an arbitrator can make a grossly wrong decision and you have no remedy, really.
Really, effectively, that's correct.
Now, and I mean, most people don't appeal a trial court judgment either, but at least you have the option. And if the judge really gets it wrong, then there's hope. But here, that's pretty scary to me. You have to have a lot of faith in your arbitrator that that's not going to happen.
You do. And I think that it's, I think that sort of endorses arbitration for issues that, may not be earth shattering, in the sense that, like, if it's a characterization issue, and the trial court judge misapplies the law, uses his or her discretion, you've got an appellate remedy available to you. In arbitration, maybe not. I think that there's definitely a little more risk, and that's why arbitration is a little bit controversial, right, in Texas, for these reasons. So.
All right. Well, we're almost out of time, but one of the questions I like to ask everybody on the podcast is, if you could give one piece of advice to young family lawyers, what would it be? When
I originally saw this question, I was thinking in terms of arbitration. So my one bit of advice about arbitration awards is understand what you're signing and advise your clients accordingly. A lot of times it's just one sentence in an MSA that agrees to arbitration, but that really leaves a lot of things unsaid. And I think you should think about the statutory implications before agreeing to sign an arbitration award. But generally, as a lawyer, I would say place emphasis on your own mental and physical health. Being a lawyer is super stressful. It is a very demanding profession. And whatever, being healthy means to you, whether it's your family relationships, relying on family, or exercising, or, travel, whatever makes you happy, you've got to put that ahead of your practice at times to be successful with this kind of practice. So.
I agree 100%. So where can our listeners go if they want to learn more about you?
Well, I have a website that is, it's audreyblairlegal.com. And emailing me is a great way to get in touch with me. My email address is on my website, but my email address is audrey@audreyblairlegal.com.
Excellent. Well, thank you so much for joining us today. And for our listeners, if you enjoyed this podcast, please take a second to leave us a review and subscribe so you can enjoy future episodes.
The Texas Family Law Insiders podcast is sponsored by the Draper Law Firm. We help people navigate divorce and child custody cases and handle family law appellate matters. For more information, visit our website at www.draperfirm.com.